Person at the jail, please state your name for the record.
Madison Reese.
This is the case of the people of the city of Cadillac versus Madison Lee Ann Reese, case number 26-270D. We are here for an arraignment on a bench warrant. Ms. Reese, it's alleged that you've violated your bond by failing to appear for an ETG on January 3rd, 2026, and failing to appear for a drug test as ordered on January 3rd, 2026. You do have the right to a contested hearing in this matter where the prosecutor would have to prove the violations to the court, or you also have the right to plead responsible. Mr. Hartel appears. How do you wish to proceed?
Yes, Your Honor. She's advised me that when it comes to the bond violation, she wished to do an admissions on that one.
All right. Is that accurate, Ms. Reese?
I didn't get a chance to hear that.
So, Mr. Hartel, the public defender, has indicated that your intent is to plead responsible to the bond violations. Is that accurate?
Yes.
Ms. Lawrence, do you have any objection to that?
No, Your Honor.
Ms. Reese, will you please raise your right hand? You swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Is it true? Well, I guess first the allegation that you failed to appear for an ETG on January 3rd, 2026. How do you plead?
Guilty.
And that you failed to appear for a drug test as ordered on January 3rd, 2026. How do you plead?
Guilty.
Has anybody promised you anything in order to get you to plead?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead?
Yes.
You were aware that you were supposed to, that you were not to consume any alcohol, illegal controlled substances, including recreational marijuana, and that you were subject to testing for both of those. Is that correct?
Yes.
And were you supposed to appear for an ETG or a urine test on January 3rd?
Yes.
And did you fail to do so?
Yes.
And did you know you were supposed to appear that day?
Yes.
How did you know?
By Wexford County Corrections.
All right. And is it also true then that you failed to appear for a drug test that day after having been ordered to do so?
Yes.
Do counsel believe the defendants provided a factual basis in which to find her guilty of the bond violations, Mr. Hartel?
I do, Your Honor.
Ms. Lawrence?
Yes, Your Honor.
As does the court, I find the defendant is in violation of her bond for failing to appear for the ETG and drug test as ordered on January 3rd of this year. That brings us as to what to do with bond. I'm assuming there's no resolution to this matter. Is that correct?
Not today, no, Your Honor.
All right, bond was originally set back on the 2nd of January. $250 had been posted. The court continued that along with the condition of, as I've said before, no alcohol, no drugs, recreational marijuana, and random testing for both.
She stated
She has requested when I met with her that, did she finally retain?
we don't have.
Okay. She had asked me earlier this morning if she could request a public defender moving forward as well. I apologize for not mentioning that.
Thank you. Ms. Reese, is it your desire then to request an appointed counsel as opposed to hiring an attorney?
Yes.
All right, so we will make the referral to the public defender's office. Mr. Hartel, then in regards to bond.
Yes, Your Honor. I would ask the court to give her another opportunity at bond. I realize there has just been a finding, but when I met with her earlier this morning, in addition to her deciding she does want to use a public defender, and I thank her for the trust and being able to do so. I may or may not be the attorney firmly assigned, but I know she'll be in good hands with my office. I do believe sometimes just having that extra wall to lean on metaphorically. There's probably better ways to say that, but sometimes that can make a difference. We have a really good office social worker. We have people who can constantly patch them into even our private cell phones we carry around. I have clients get a hold of me after hours all the time. We have email, they can get a hold of us. There'll just be not that there's ever really an excuse, but there'll definitely be less chance of any issues moving forward. I asked the court to give her that opportunity now that she does have that added support structure. Thank you.
Ms. Lawrence, before I allow you to allocute, I see, looks like the violation was only for the 3rd, but I see in the file there was a missed test on the 4th as well.
I did just realize that. I think I forgot to add the 4th date to the petition. I'm fine with just going forward today with the 3rd violation.
All right. Allocution then?
I honestly intended to ask for a remand for the time being in this case. She got put on bond on the 2nd, I believe, and then is violating the very next day. I also will note, I'm sure the court has read, but the comments that she made to community corrections, which is included in that paper, is extremely concerning. She basically tells them this is BS. I am not giving up my pot. Her boyfriend also stated he just spent over $200 at the liquor store on booze for their party. And then after these comments were made, she then refuses to show up for tests on not only Saturday, but Sunday as well. So I do think maybe a little reading between the lines for that one, but I don't necessarily think this defendant is taking bond conditions seriously at all. The fact that she is already violating after only being on bond for a day does cause the people some concern, especially with the underlying charge being an operating while intoxicated. So for the time being, I would ask for a remand. Thank you.
Thank you. Ms. Matsky, has she tested at all?
She did test in Osceola County on Friday. Only a PBT though. I don't believe she got a drug test.
Okay, was that when she was picked up on the warrant then?
Yes.
And when she appeared to sign up for testing, was there a test done then at all?
There was not.
Okay. All right, the court has somebody who does not have a prior criminal history, but is alleged to have operated while intoxicated, including an accident with a rollover on Sunnyside Drive, which is a street here in the city of Cadillac. She actually posted bond back on the 31st of December. However, conditions were put on her on the 2nd, and the first 2 attempts out of the gate, she fails to appear. Ms. Lawrence has already made reference to the comments about how this is basically bullshit. She's not giving up her pot. And it's also states in there that she did not read the rules of enrollment. So I have somebody who is not going to take the court's orders very seriously, if at all. And as such, I do find that she is a threat to the public, and bond will be revoked. Next arraignment.